Attention please, attention please. Thank you for joining us in this act of remembrance. We will remember them.
here, and that's something we will share with you once we have those tangible examples. And then sort of the most significant for us in terms of what we're required to supervise are the money laundering regulations. The latest version came in 2017, and these have been amended since, most notably in 2019. And essentially this requires those working in areas that could potentially be misused by criminals to launder money, such as law firms and accountants, to have certain preventative measures in place. It also sets the requirements on us for a supervisor, such as having to look at policies, controls and procedures, conduct visits. That's sort of where my team come in to meet that legal obligation. And also we're required to have sufficient enforcement powers where things do go wrong. So in terms of us as a supervisor, we are the largest legal sector supervisor. So roughly 2/3 of our population of law firms do work within scope of the regulations. So that equates to 6,500 law firms. And we're also regulated ourselves by the Office for Professional Body Anti-Money Laundering Supervision, quite a mouthful, OPBAS. So they also assess our work as well in this area. So in terms of the basics to know, you need to first determine whether or not you are in scope of the regulations. So in terms of legal professionals, you need to have a look at Regulation 11 and Regulation 12. And what that tends to be is if you're doing conveyancing, company, commercial work, offering tax advice, setting up companies or trusts, then you will be in scope of the regulations. You need to be mindful of those areas which traditionally wouldn't be in scope, such as employment law, for example. But if you're dealing with an employment law matter and then you then give subsequent tax advice, that is going to bring you in scope, so do be mindful of that. Similarly with personal injury work, if you then set up a trust at the end for damages, that will also bring you into scope. So if you are in scope, most firms, unless you're a sole practitioner or a very small firm, you will need to have a money laundering compliance officer, and they sort of have the overall responsibility to ensure you're meeting the requirements in the regulations. And you'll also need to have a money laundering reporting officer responsible for making disclosures to the National Crime Agency. So do make sure that everyone in your firm knows who those people are, how they report any suspicious activity and what to look out for. And you need to have proportionate policies, controls and procedures. So if you are using templates, which are absolutely helpful as a starting point or may do the complete job, do just ensure that they're proportionate to your type of business, your firms. Are they user friendly? If I'm a fee earner, can I understand what I need to be doing, what due diligence look like and what enhanced measures might be? You'll also need to train your staff and maintain training records and monitor those. That is one of the things we ask for when we come and see firms. And you'll need to do risk-based customer due diligence and record your decisions. So, for example, if you are acting on a conveyancing matter, which is traditionally high risk in the sectoral risk assessment that we've set that you have to have regards to, but you've determined it's actually low risk, maybe because you know the client, you've acted on the sale of a purchase and they're now buying another one, and you've previously looked into their wealth on other matters, then simply write a line saying that on the file and say, these documents are on file 004 or whatever. And that tells anyone else looking at that file what to do, but also if we were to select it, it shows a very clear rationale of why you've deviated from potentially an area that otherwise would be considered high risk. And then also you'll need to get your beneficial owners, officers and managers approved by us. So if you're unsure as to who those role holders might be in your firm, there's very detailed guidance about that on our website. So yeah, in terms of continuing the basics to know, so you need to do a firm-wide risk assessment, and that has to cover 5 mandatory areas which are set out in Regulation 18 in terms of assessing the risk of your clients, delivery channels, transactions, services and geographical locations. And this is really important because it sets the tone for all of the other documents that may well flow from that, and it also sets your risk appetite as a firm in terms of what you tolerate, what you consider out of the ordinary or high risk, and where further measures need to be applied. Then flowing from that, you need to do an individual matter and client risk assessment, and that needs to, at the very least, ensure that it would identify anything that is high risk in the regulations where you must apply enhanced due diligence, but also anything in your firm-wide risk assessments, and making sure that's a real useful document, and we'll talk a bit more about that later. You also have to have sorry, I think I'm still on the same slide. No, yes, train your staff, which we've already mentioned. Yep, so let's move on from this one. So in terms of the changes that came in 2019, these are some of the significant ones I wanted to mention. They're nowhere near as big as sort of the 2017 changes themselves, but the definition of tax advisor has been widened, so it will bring firms that weren't in scope now into scope of the regulations. So in terms of tax advice, that's where you're providing material aid, advice or assistance, but that's sometimes not just directly, it now brings into scope where you provide that advice through a third party. You're also required to report customer due diligence discrepancies. So if you've been given documents or information by your client and that differs to what's recorded on Companies House, you have to report that. And there's a portal to do so on Companies House websites. I would say you don't need to actively look and be an investigator to find those problems. It's only if they come up the duty to report is activated. And there's been some minor changes to when you need to apply enhanced due diligence. So if a transaction's complex or unusually large, or there's an unusual pattern, you now need to apply enhanced due diligence. It previously was and, so it would be, you'd have to have more than one of those things for enhanced due diligence to be triggered. And also you have to apply enhanced due diligence where there's a link to an EU high-risk third country. So that's previously been the EC list, but I would say that's recently been amended and it's now Schedule 3ZA in the regulations that sets out the list of those countries. So we've touched upon the Proceeds of Crime Act, but just to sort of flesh out that you need to know the warning signs of money laundering. So making sure that fee earners are aware what to look out for and when that should be reported, such as clients being evasive or wanting to rush through a transaction without real rationale. I think the most valuable question here in terms of moving us away from a tick box approach is simply asking why. Why have I been instructed as a firm if the transaction is overseas and you're quite a niche small practice, and why does the client want to do this? That can usually be the most effective questions, instead of going, I've got to get this form, I've got to get that, and not reading them. And also making sure, as I said, about the role of the money laundering reporting officer, that staff know who to tell if there is something they're suspicious about, and that you have some sort of process. Having an internal process doesn't mean you have to have an ISAR form. If you simply keep a folder in your Outlook, if any of you are the money laundering reporting officer, that would absolutely suffice. And then, of course, where that responsibility is engaged, making sure you do report to the National Crime Agency. And you'll see on the slide, that's whether or not you turn the client away. I think there's a bit of a misunderstanding that the reporting regime is only used for defence against money laundering SARs, where you want to proceed with a transaction. You still are required to report suspicion. So if you turn a client away and you've met the threshold for suspicion, then you still need to report that. And that's also, of course, not just a legal obligation, but it's in the national interest to do so. And we have seen examples where law enforcement have pieced these things together and successfully kept people safe and dealt with crime. So in terms of going on to what we've been doing, and you'll see the last year in numbers on the slide. So we visited 85 law firms. We've conducted 70 desk-based reviews. So in terms of a visit and a desk-based review and how those differ, with a visit, we'll call in policy controls and procedures, we'll look at a sample of files, and we'll interview key role holders at the firm. So we'll be speaking with the MLCO and MLRO if they're different people, and we'll also want to speak with a couple of fee earners as well to see what's happening on the ground. With a desk-based review, it's sort of everything I've just said without the interview. So we'll still look at the same documents, we'll still look at some files. And then in terms of other reviews, we've reviewed nearly 100 firm-wide risk assessments, and there's some figures on there in terms of the reports we've seen, which I'll go on to give you a bit more detail about the kind of things we're seeing there. So in terms of visits, given the risk in this area and how important preventing crime is to us in terms of, as a legal regulator, we have a regulatory objective to protect the public. We are doing a lot of work in this area, and if AML is something you follow closely, you will have seen that in the legal press. And although compliance is not optional when it comes to the law, with our supervision, hopefully you've also seen that we are pragmatic. And if we see a firm that's partially compliant, then we will, where possible, try and help them, bring them back into compliance. Now, of course, that doesn't mean we don't take action at all. Where we do find systemic serious non-compliance, we do treat it seriously. But if a firm is trying to comply in a lot of areas, the first thing we will do is try and look to supervise. And I think that's echoed in the numbers. So in terms of over half of firms that we saw required some corrective action, ranging from engagement, so where we would write a letter essentially saying you need to do these things, can we see a copy or can you confirm those are done, to a compliance plan where there may be several things that need to be done at different time frames, and we set out a plan that's helpful to the firm and to us as a regulator about our expectations, and we agree time frames with them for that action to being done. So that was around half of firms required that type of action, and then just over 10% were referred for formal action. So you'll see in our report, we've recently published an annual report which we're required to do so under the legislation, and that has a lot more detail about our activity, and it's kind of broken down by theme, but you'll see that referrals, there's several tables in there, they tended to be where multiple AML concerns were cropping up. So for example, if firms weren't conducting source of funds checks where it was necessary, or there were non-compliant policies, and also there was a failure to carry out ongoing monitoring. In terms of the desk-based reviews, I suppose it's worth noting that we contact firms on a monthly basis to conduct these desk-based reviews, and the vast majority of firms do comply with our requests, so we have powers under the regulations to request documents and under our own rules. We did refer one firm for non-compliance with our request, whereby we'd been in contact with them for a long time and didn't receive the documents, but as I say, the majority of firms do comply. There's two types of reviews we did in the last reporting period. So as I said, we did around 100 firm-wide risk assessment reviews. Half of those were partially compliant, and similarly, just over 10% were not compliant and referred. And for some of those, I would say shockingly, they didn't have a firm-wide risk assessment in place, or one was created after our request. And I say that because these were brought in 2017. We've put out a lot of guidance now, and you would hope firms know that that is a requirement. In terms of the desk-based reviews, I would say that 25 out of the 70 are ongoing, so I haven't got any information on those ones for you, but the remaining majority were partially compliant, so we're seeing a similar theme and required us to take steps to be taken. We're also seeing similar findings, which I'll go on to talk about from our visits, in terms of key things that firms have been struggling with. So one of the things that firms have been struggling with is ensuring their policies are compliant. So as you'll see, 55% of policies did require some improvement, and nearly half of those that we saw hadn't been updated to reflect the amendments that came into force in 2019. So in terms of giving you a flavour of some common omissions, things that were missing were information on high-risk third countries, whether simplified due diligence was permitted, whether reliance is permitted, and the position on enhanced due diligence. And I'd stress that all of those are mandatory under Regulation 19. So if at your firm you don't apply simplified due diligence or you don't permit reliance, you have to say that in your policy to make sure that people aren't doing that. Another theme that we continue to talk about is firm-wide risk assessments, as I mentioned. There is lots of guidance on this, and as I said, we have referred firms where they've not got one, or one looks to be being created after our request. In terms of the most common issues with firm-wide risk assessments, we are finding it's transactions. So firms aren't talking about what is the typical value and size of transaction, what would be out of the ordinary, what would be considered high value. The other common thing we're seeing is that not all services are commented upon. So if you go on a firm's website, they're advertising they do other things, but they've not assessed the risk of that in their firm-wide risk assessment, which you have to. And similarly, delivery channels was missing or out of date. So in the last 2 years, we've obviously all had to deal with COVID, and we've moved some of our visits remotely and worked well with firms about that. That should have been a trigger to review your firm-wide risk assessment and look at, have I said in my assessment I only deal with people face-to-face? Clearly I'm not doing that now for the majority of firms. What is the risk? What have I put in place to mitigate that risk? So that would come under delivery channel risk, and that's another common thing we're seeing. In terms of audits, again, the number of firms with issue remains high. Whether you need to do an audit is based on your size and nature of your firm. So things to consider: do you have a middle level of management? So the owners of the firm haven't got sort of direct knowledge of what's going on the ground? Do you have multiple offices? Are you doing high risk work? Those kind of factors are going to trigger the need to do an independent audit. And then in terms of what does this mean, independent doesn't have to be external, but you can't mark your own homework. So if the MLCO MLRO's written the policies, you can't then audit them. You're not sufficiently independent for that. Similarly, if you've used a consultant to draft your policies, controls and procedures, that same consultant can't audit them because they're not sufficiently independent from the documents themselves. You also need to assess adequacy and effectiveness. So other things we've seen, if you do any accreditations for your firm and you think that satisfies the audit, do take another look and see if you need to do anything supplementary. Have they sufficiently looked at file reviews? Are they looking at all the requirements within the regulations to assess the effectiveness on the ground? And then finally, any independent audit needs to produce recommendations as to what you need to do to bring your firm into compliance, and they need to be monitored. And I would say if we're visiting a firm that's had an audit, that is something we're going to ask for, and we're going to expect that you have actioned those recommendations and progressed anything that was spotted as being non-compliant by your auditor. So in terms of screening, I'm not going to talk too much about this. I think firms have really improved in this space in terms of screening their employees. Where there could be some improvement is around ongoing screening. So we have seen that nearly 3/4 of firms are carrying out appraisals and file reviews, which are a low-cost option for ongoing screening. But there's also some free options, so doing media searches against employees or contacting us as the regulator to check their regulatory history. Have we made any findings against them? Do that. And we are seeing, in terms of you take a risk-based approach as to what checks you do for employees, we are seeing a high number of firms, the majority, are doing disclosure and barring services checks at the beginning when they appoint people, and just over half are also doing that for existing staff. So something to think about, but definitely not mandatory. So in terms of customer due diligence, I think one of the biggest concerns is that we found that the policies, controls and procedures were not reflected on the files we saw. So what was happening on the ground was not what should have been happening, and was not what we were told by the MLCO MLRO was happening. And I think with matter risk assessment, similarly, these weren't being done, or it was a form that wasn't then rated. So essentially there was something there, but you hadn't actually assessed the risk. And that applied on over a third of files that we saw, so quite significant. And similarly with source of funds, nearly half of the files did not have source of funds evidence where it was necessary to do so. I recognise with source of funds this is a really challenging area. We have tried to get the legislation tightened up in terms of where necessary is quite a woolly term, and I think there's some factors that hopefully have helped you. So always consult Regulation 33 areas, and Regulation 35 is politically exposed persons. So there's some areas that it's absolutely a must to do source of funds, and then I think you just need to work out, do I sufficiently understand this transaction without looking into source of funds? And similarly to earlier, making a note as to why you didn't think it was necessary. If it's in a higher risk area, definitely. And similarly, set out in your policy, what is your tolerance, what are your expectations for fee earners on files in relation to source of funds, what would you expect to see? We found that in over a quarter of policies we saw, that wasn't set out in their policies, controls and procedures. And then in terms of ongoing monitoring, this is probably one of the things that concerns me the most. I think it's a common area for enforcement to be mindful of. And again, you need a method to recognise any changes in that matter. So has the client changed? Has the source of the funds changed? Parties to the transaction? So making sure fee earners have the knowledge. I think smaller firms are doing this better than larger firms. It's a challenge for larger firms if they've got a compliance team. How are they getting that information direct from the client? Whereas in smaller firms, if the fee earner is responsible for due diligence, I think that can sometimes work better. We've seen some good examples in larger firms where their systems supplement that, so there's a trigger to review due diligence or the matter risk assessment to check it's still relevant. And then in terms of enforcement, we've seen an increase in the reports that we've made. So in terms of what these have concerned, we've had a lot for non-cooperation with our requests. failure to carry out source of funds, so you're seeing a theme here where necessary, and failure to complete customer due diligence. You won't be surprised that the most common area of law that we receive reports was in relation to conveyancing. And in terms of, we tried to look back and assess what key themes have we identified that has led to these failures. And we found that for some it's where there's inadequate supervision, as you can see, or inadequate policies, controls and procedures, which is really a firm's responsibility. But then we have seen, you know, to put your mind at rest, if you have got sufficient PCPs, you are supervising, and individuals are still deciding to not follow that, then the action will be taken against the individual and not the firm. And if that's something you're interested in looking into, sort of where it has gone wrong, there are case studies that link to the actual judgments at the bottom of the report for you to check out. So just wrapping up here, so I've covered a lot. There's obviously a lot of help on the website, and you can come and speak to us as well through professional ethics, or I'm about for a bit. But I think if I could say, you know, a reminder or wrap up of what I think the three key areas which firms are falling short on, I would say it's matter risk assessments, as I mentioned, being clear in your rationale, how you've reached that. And you may be able to influence behaviour in your firm by making sure your matter risk assessment is use a form that is very clear what you expect in that area. Policies, controls and procedures is the second point, and I'd say make sure they actually reflect the processes that you have as a firm on the ground. And then finally, ongoing monitoring, as I mentioned. How are you doing this? How are fee earners or those touching the matter aware of what would trigger a change in risk factor or a change in the due diligence required? So I'm going to stop talking now, and if anyone's got any questions, please feel free. No? Okay, well, I'm about on the stand anyway for half an hour or so if anyone wanted to chat one-to-one, happy to do so. And thanks for listening.